Watch, Mark, we've got a major Supreme Court ruling here, 6-3 in Donald Trump's favor. Can you explain what this ruling allows Trump to do?
Yeah, so the Supreme Court, as part of its shadow docket, has overturned or at least blocked for now a lower court decision that made it illegal for, in the words of that lower court, the government to, quote, conduct roving patrols which identify people based upon race alone, aggressively question them, and then detain them without a warrant, without their consent, and without reasonable suspicion that they are without status. I mean, I have to tell you, Brian, even by this Supreme Court standards, I am taken aback by this. You essentially have the U.S. Supreme Court blessing the use of race and language and job status as the grounds to detain people. And, Justice Kavanaugh, who issued the only written statement sort of defending this, made it sound like this might be a minor inconvenience for people who are wrongfully detained, who may, for example, be U.S. citizens or otherwise lawfully here. I don't think that that is, in fact, with all due respect to Justice Kavanaugh, a fair reading of what the hell is going on in cities like Los Angeles.
And so what is the principal pushback? Why did the district court, for example, rule against this in defiance for what would eventually be the Supreme Court's ruling overturning it?
It is frankly not hard to see what that pushback is, which is that you should not be able in the United States of America in 2025 to be pulled over, to be detained, to be questioned based on the fact that you speak Spanish, look Latino, and do some sort of day labor. Like, it is simply wrong that in a world in which the Supreme Court is saying that race may not be used in college admissions, in which, it is considering whether or not race or language can be used in the drawing of congressional districts with protection of voting rights for those racial and language minorities, that you can, however, be pulled over by a roving band of federal officials on those same criteria. I mean, it is. I spent a lot of time trying to explain what it is that federal courts are doing. And I try to be even-handed, even when I disagree with the Supreme Court or I disagree with a federal court's decision in articulating what the rationale is or what the debate is. This one is hard to justify what the rationale or the debate is.
There is an existing case right now that's working its way through the courts that you and I have spoken about at length, and that is Newsom versus Trump, where already Judge Breyer, a trial court judge in California, had blocked Trump's ability to be able to deploy troops to this state. That is, of course, being appealed up to the Ninth Circuit Court of Appeals, so we're waiting on a decision from them. But is there any relationship between these two? Because in effect, I mean, the only way to get these roving ICE armies into the states is to be able to deploy them. So if you have a judge in California who's already said that you're not allowed to deploy federal troops, does that have no bearing on the prospect of also being able to deploy ICE agents?
It doesn't, because ICE agents are not the military, right? The Posse Comitatus Act, which was the basis of the Newsom v. Trump case, prohibits the use of the U.S. military for domestic law enforcement. And so the question that Judge Breyer had to deal with was specific to the National Guard, and the Marines, I believe, were also deployed in Los Angeles. And that is a longstanding principle of statutory and constitutional law in the United States, that we simply do not deploy the military as a domestic police force in this country. ICE, on the other hand, is a Article 1. It is a branch of the executive branch. It is a type of federal law enforcement agency, as you point out, and therefore its deployment does not trigger review under the Posse Comitatus Act. What it should be triggering, which this case is about, is a question of whether or not it is engaged in racial profiling. And not only whether it's engaged in racial profiling or language profiling, but whether it can do so, frankly, pretty explicitly.
Yeah.
And that is, like I said, a surprising outcome even for someone like me who, views the Supreme Court as pretty conservative on these issues. I am frankly taken aback that the Supreme Court, or at least, some portion of the Supreme Court, it's hard to know because these shadow docket rulings, you don't get the benefit of knowing what all six justices think. You're sort of piecing it together from the various pleadings and from, in this case, the single concurrence of one justice, Justice Kavanaugh, and the dissent, a very stern and fiery dissent on the behalf of Justice Sotomayor. So I am assuming that she knows, more than I do. And when she writes, quote, "We should not have to live in a country where the government can seize anyone who looks Latino, speaks Spanish, and appears to work a low-wage job." I mean, it is hard to believe that that is a controversial position, but apparently it is not one shared by a majority of the Supreme Court.
Is there any concern, Mark, that by virtue of allowing ICE carte blanche to be able to go into the states and do this, that this will be a pretext to be able to incite the very violence that Trump then uses as his justification to send his troops in? Like we saw in Los Angeles when ICE was deployed, Trump then pointed to the response to ICE being deployed here in LA as his rationale for being able to send in the National Guard and send in the Marines. And so if he's looking for some excuse to be able to retroactively justify his troop deployments, can't this be his basis for doing that?
Absolutely. And I think that, it is a thinly veiled pretext, by the way. I don't know how, I think Donald Trump is happy with this decision, not just because he wins, but because it allows that pretext to be pretty explicit, right? I mean, this is going to only encourage Donald Trump to send in ICE and other law enforcement on using race and language and jobs as a thinly veiled criteria to stop people. That is going to inflame a lot of people, including, by the way, a lot of U.S. citizens, right? I mean, a lot of U.S. citizens speak Spanish. There is a large Latino U.S. citizen population in this country. And so it is going to, I think, on Donald Trump's part, be a calculated effort to trigger an outrage and a response that will then be the pretext by which he sends in federal military and National Guardsmen. And I wrote about this for Democracy Docket, a piece that I did this morning about the outrage and the fury that I feel and many other people feel. I know you do. That in Germany in the early 1930s, it was a fire in the Reichstag that was the excuse, right? It may not be a fire here. It may be something in a Home Depot parking lot, but Donald Trump is looking for that excuse, and we've seen that excuse, as you say, play out already in Los Angeles. But I don't think we've seen the end of it.
Just a quick note for everybody watching. I would not be able to cover any of this stuff, these monumentally important cases, without using Democracy Docket, which is the news outlet that Mark founded to focus on everything voting and elections. It is, again, a resource I use on a daily basis. If you are not yet subscribed, please do yourself a favor and subscribe. You'll not only stay up to date on all of these very important cases, but also be able to support the work that Mark and his team are doing. So I'm going to put that link right here on the screen and also in the post description of this video. Again, if you're not yet subscribed, please make sure to go ahead and subscribe. Mark, does the fact that we saw this ruling 6-3 in Trump's favor, a pretty ridiculous ruling, I think we can glean from your response here, does that offer any insight into how the Supreme Court might rule in the event that this Newsom v. Trump case, which is again working its way through the trial court, is now at the Ninth Circuit Court of Appeals and will almost certainly be appealed all the way up to the Supreme Court by one party or the other? Does this give any indication as to how they might rule on this case, given that they're giving Trump so much leeway here?
Sure, I sure hope not. I mean, I'm not gonna lie to people. I mean, you and I do this series to give it to people straight, and so yeah. It worries me a lot that it might. I would have thought this was one of the cases that more clearly fell on one side of the line, and obviously 6 justices of the Supreme Court, at least on a preliminary basis, don't seem to think so. But the Posse Comitatus Act is as storied a part of the American legal tradition as there is in any law. I mean, this is a law that goes back to nearly the founding of the Republic, and it was based on a genuine historical concern under the British about the deployment and the misuse of, in that case, the British soldiers in U.S. cities and to operate as a police force. So we have a long constitutional and statutory tradition against what Judge Breyer found out of bounds in the Trump v. I'm sorry, in the Newsom v. Trump case. And I would certainly hope that the Supreme Court, even if it is willing to allow the use of race and language and the like in this instance in a way that I find pernicious, even if they're willing to allow that, that they will abide by the clear text of the Posse Comitatus Act and the clear findings of the trial court. I mean, I think if we wind up doing a video that the Supreme Court has reversed that case, one of two things has happened. Either the Supreme Court has simply, abdicated commitment to this longstanding federal law, or it decides that it is going to reinterpret the facts in a way that are contradicting what Judge Breyer said. And that is really not the role of an appellate court. I mean, this is a case where Judge Breyer held a full trial. He allowed both sides to put on witnesses, and then he made findings of fact. And those findings of fact are entitled under applicable legal precedent, including Supreme Court precedent, to substantial deference, subject only to an abuse of discretion. It is only if the Court of Appeals, the Ninth Circuit, or the Supreme Court looks at the findings that Judge Breyer made with respect to what these troops were doing and says that it was clearly erroneous, that when reading the trial transcripts, a rational judge could not possibly have found that these troops were acting in a law enforcement capacity. That is hard to imagine in this case, but that would be what we would be looking at.
Mark, has there been an instance that you can remember where the Supreme Court has defied the clearly erroneous standard and kind of just ruled however they wanted to rule, regardless of the presence of some clear error?
Yeah, it's a really interesting question, and it's one that gets debated by Supreme Court scholars all the time, because there are certainly some cases where the court either seems to just ignore, like it just kind of like, it doesn't say it is finding clear error. It doesn't say it's not finding clear error. It just kind of like magically recasts the facts, seemingly. And that has been the subject of some scholarly criticism in a handful of cases.
Well, I presume like the case regarding presidential immunity, there was no court lower than the Supreme Court that said that existed, much less was well founded.
That was a different thing, though. There, in fairness to the Supreme Court there was not disregarding the findings of fact of the lower court. They were saying that the lower court got the law wrong. Okay. So here, I don't think they are going to easily be able to say that Judge Breyer got the law of posse comitatus wrong, because the law of posse comitatus is not that complicated. You cannot have federal troops. You cannot have the military performing law enforcement functions. And so the question of whether they are performing law enforcement functions is a question of fact, right? That's not a question of law, right? And so Judge Breyer has found, as a matter of fact, that what they were doing was law enforcement functions. And so I think that that's going to be a hard case for them to get around, although, like I said, there have been some instances where, people have criticized the Supreme Court for seemingly ignoring the standard. And there are the rare cases where the Supreme Court does say that they think that the clear error standard has been met. That is usually cases, though, that involve expert testimony, where the justices look at complex expert testimony, a statistical report or something like that, and they say they think the trial judges just misunderstood, honestly, what the expert analysis was. I'm not saying that should happen, but that is usually the context. Here, this is quintessentially what you have trial judges for. You have trial judges to put on the stand people who were present at an event, in this case, present in the cities of Los Angeles, and they testify as to what happened, who did what to who. And that is exactly why you have trial judges, and courts of appeals are not supposed to disturb those findings of fact. And that is why you have such a high standard of deference to those trial court findings of fact. We'll see what happens when this goes to the Ninth Circuit. We'll see what happens when this goes to the Supreme Court. But I do think that is going to be a much steeper hill to climb, unless the court just says, look, we think the Posse Comitatus Act is inconsistent with Article 2 of the Constitution and presidential powers. Like I said, that would be an earthquake unto itself. That would require them to say that the Posse Comitatus Act essentially is unconstitutional.
Yeah, well, I mean, look, they've gone after the Voting Rights Act, they've gone after Roe versus Wade, and so it wouldn't be the most surprising thing in the world that as they
No,
continue
although this is a law
chip
that was
away.
passed in the early 1800s
Yeah,
by the founders for a specific reason. You know what I mean?
yeah.
Like this is not like something that was passed in 1965.
Right, right. Well, look, your reporting again on this particular issue has been absolutely essential. So a reminder for everybody who has not yet subscribed to Democracy Docket, please make sure to subscribe. I'm going to put the link right here on the screen and also in the post description of this video. It'll not only give you access to fearless independent journalism, but help support the work of Mark and his team. I'm Brian Tyler Cohen.
I'm Mark Elias.
This is Democracy Watch.